Your statement, sir.
Well, now, ladies and gentlemen of the
like you, be strong to hold the powers of the sun.
All I'm offering is the truth, nothing more.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, here to discuss the Idaho 4 case. And in this episode, in an effort to keep you apprised of everything that's going on in this case, I'm going to break down a couple of docs for you, a couple of simple ones, and I'm going to show you how we're dealing with two different levels of lawyering between the prosecution and the defense. And I'm going to break down a couple of these docs that, that go to show that. And, it's amazing to me that I listen to, people out there. There's been 40 docs drop, right? And out of those 40 docs, about 39 of them, if you really read them closely, go towards the innocence of Bryan Kohberger by any measure of interpretation if you really break them down. That one doc, the one doc where they, throw in the BS smoke and mirrors about the K-bar knife sheath and the fact that they have a, witness that's going to testify to that K-bar knife sheath. I mean, you wouldn't need a witness to testify to a purchase that you had a receipt for, number one. I've already said that. But number two, how people jump to conclusions based on footnotes in these things. And I even listened to, to Harsh repeat something that he heard the drunk dog chew toy mentioned in one of his videos yesterday. He said, I believe Bryan Kohbergers' family is going to testify against him. Oh, really? Well, you could have only got that determination from listening to the drunk dog chew toy and misinterpreting what he's reading in a court doc. So what I want to do in this one is I'm going to break down a couple of these docs. We're going to answer some of these questions for you and see where we stand on this. Even the selfie, of all these documents with all of this information, they focus in on that one statement in that one doc and then the selfie that's attached to the bushy eyebrows statement. And then when I look at the picture of the selfie that they put on mainstream media, they even crop out his shower curtain you can clearly see hanging there. People, you got to open your eyes, especially people that are out there talking on behalf of possible innocence in the case. I mean, if you're going to talk on behalf of possible innocence, but then you're going to take every little mainstream moron thing that they say to heart, you're not really being genuine. And that's why I've warned y'all for a long time. I mean, see, I'm probably the best person to bring this to you from the perspective of I know Bryan Kohberger's innocent, because I didn't wake up one day and go, hey, I feel like Bryan Kohberger's innocent. No, I went and set out to prove he was guilty. If you go back to my channel, that's what I did. Now, I knew the circumstances around this were quite different than we were being told, and I set forth in an effort to prove that, not only were those circumstances wrong, this was the real reality of what happened here and the real reality of why it happened, but I also set out to prove it was Bryan Kohberger that was the assailant that carried it out. And along that journey, those of you that have been with me, you know that I found evidence otherwise. And I found evidence that proved that Bryan Kohberger couldn't have done it. So when I bring it to you, I'm not bringing it to you from a perspective of, it's just truth and justice for all and all that. No, I'm bringing it to you from a perspective of, they got this guy up there that didn't do it. So I can look at evidence and I can look at it with an open mind and I can see it for what it is. But then you got these people out there that claim to believe, in truth and justice and a fair trial and innocent until proven guilty, just to say a bunch of stuff. And then the first little sign they see is, oh, wait, I guess maybe he is guilty. But then you got these other nefarious characters out there that I've warned you about, like Murphy the dog. Now, if you go back and you look at his work, this is what kills me. I mean, this is what gives it away. If you look at his work, nothing about his work involved the K-bar knife sheath. Nothing. It was all vehicle identification, all kinds of technical stuff around the crime scene, suspect vehicle number 5. Yet, strangely enough, he put out a post, I think yesterday or the day before, that says, well, it looks like law enforcement got this one right after all, and he's going to do one last video, and it looks like truth and justice worked. Yeah, right. It worked in your favor because you were working for them all along, and I called you out on it a long time ago, and you just showed your true colors. So for all of you that followed him and really believed him, sorry for you, because all he was doing was trying to take people that had an open mind and shift their view to guilty the entire time. And he feels like his job is done. So my job certainly isn't done, because this thing is far from over. And we're going to get into some docs that lend to that idea. Let's roll. First, let's go back in time to the original state's motion in limine for improper death penalty comments. And you can see the prosecuting attorney respectfully moves the court for an order in limine prohibiting the defense from making any reference to the state attempting to kill their client, Bryan Kohbergers. The state brings this motion based on defense counsel's repeated references to the state attempting to kill their client. Defendant, in his reply to the state's objection to defendant's second motion to dismiss the indictment, how many motions to dismiss were they really? The state had decided attempting to kill Mr. Kohberger on October 26th. Then during oral argument on defendant's motion to dismiss indictment, defense counsel stated, this does not rise to what we would expect our government to do in this scenario where they're trying to kill one of us. Again, on January 25th, 2024, during oral arguments on defendant's motion to reconsider, defense counsel stated, particularly in a case where the state decided that it wants to try to kill someone, and the state has filed a notion of intent to seek death penalty. Upon finding a guilt, the state intends to provide statutory aggravating factors which could enable a jury to impose the death penalty. And this process is laid out by Idaho law. Another characterization, such as the statement that the state is attempting to kill, only serves to inflame the passions of the jury. The statements are irrelevant. And then they cite down here, you'll see ICJI 700C. Just remember that one. And in that one, it states, at the conclusion of trial, you will decide whether the state has proved the defendant guilty beyond a reasonable doubt. Do not concern yourself with the subject of penalty or punishment. That subject must not in any way affect your verdict. So that's the state's argument on that because of this little ICJI 700C that they cited, right? Don't concern yourself with the subject of penalty or punishment. That subject must not in any way affect your verdict. Okay, so now let's move forward in time. Okay, so this is the defendant's response to the state's motion in limine of the improper death penalty comments. And you can see Bryan Kohbergers, through his attorneys, wants to respond to that. And Mr. Kohbergers faces 4 counts of first-degree murder. The charges began with an arrest warrant and complaint. The state chose the grand jury process rather than preliminary hearing, and the grand jury returned the indictment. Thereafter, the state chose to file its notice of intent to seek death. The jury selected to try Mr. Kohbergers' case will be aware the state is seeking the death penalty. They will be informed at the outset for a variety of reasons. Mr. Kohbergers must have a way of conducting voir dire with prospective jurors. He must be able to examine witnesses and present arguments in trial. Mr. Kohbergers suggests, I love this statement. Mr. Kohbergers suggests he use phrases that comport with existing language in statute and jury instruction. Mr. Kohbergers suggests he use phrases that comport with existing language in statute and jury instruction. But you see, they got the little footnote 1 right here. So let's go down here. The footnote 1, the state pointed to the court to ICJA 700C as how the jury would be instructed. But the jurors will also hear ICJ1 or ICJI 700B when jury instructions are read. So, since they're hearing that one as well, Mr. Kohberger suggests he uses phrases that comport with existing language in statute and jury instruction. Well, what's the difference in 700C and 700B? Well, I just read you 700C. Let's look at 700B, shall we? Okay, here is 700B, ICJI 700B. Got it. The state is seeking the death penalty in this case. If the defendant is convicted of murder in the first degree, there will be a separate sentencing phase of the trial. In that sentencing phase, additional evidence may be presented to the jury and will be given additional instructions. If the jury finds a statutory aggravating circumstance but finds that death would be unjust, the judge will sentence the defendant to a term of fixed life imprisonment. If the jury does not find a statutory aggravating circumstance, the jury must then sentence the defendant to life in prison, and the judge must set a fixed period of imprisonment of anywhere from 10 years up to life, during which the defendant will not be eligible for parole. In this instruction should only be given if the defendant is charged with murder in the first degree and a valid death notice has been filed. This instruction should be given in the guilt phase of a capital case. So, the guilt phase, it needs to be given in a capital case. So, since they're going to voir dire the jury for the guilt phase of the case, to ignore the fact that the state is seeking the death penalty would not align very well with ICJI 700B. So, yeah, good try, state. So kind of a tricky move there by the state. They tried to eliminate language that would be necessary for proper voir dire if the death penalty is not removed from the case and death penalty qualified jury is allowed to be seated. So very slick, caught on to by the defense and slapped down. I don't think there's any way that a judge could not rule in favor of the defense on that one. But let's move forward now, because we hear all this talk out there about how Bryan Kohbergers' family is against him. They've turned him in. They're testifying against him. I mean, well, they're just hitting it hard and heavy, and they're bringing every dinkle dob along with them with their mainstream moron chanting. So let's address it with a court doc. All right, let's go to defendant's response and objection to the state's motion in limine. Immediate family members in courtroom. You can see that Bryan Kohberger, through his attorneys of record, hereby responds and objects to the state's motion in limine about immediate family members in the courtroom. Specifically, the state asked the court for guidance on which immediate family members are allowed in the courtroom for the entirety of the trial. Mr. Kohberger objects to this request on the basis that it is too narrow in scope and that the court's guidance should be broadened to address related topics discussed below. First, the individuals identified by the state as family members of the victims include mothers, fathers, stepmother, stepfather, brothers, sisters, stepsisters, grandmothers, and let me add cousins, brothers, sisters, former roommates.
I am your father's brother's nephew's cousin's former roommate.
What's that make us?
Absolutely nothing, which is what you are about to become.
No, that I added that. That wasn't in there. Acknowledging that the term immediate families is undefined in the state's motion, asked the court for guidance on what immediate family means. And they're not being too strict on it. They go through Black's Law Dictionary talking about what, immediate family actually means. But at the end here, Mr. Kohberger stipulates to the individuals listed on Exhibit S1 as being considered immediate family. So he's like, okay, y'all bring them all in. Everybody on your list is immediate family. We're fine with that. We stipulate it. Bring them in. But second, Mr. Kohberger respectfully requests that the court's guidance outline proper courtroom decorum, which discourages spectators from wearing T-shirts with a picture of the victim on them and the words "in memory of," or T-shirts about shooting Mr. Kohberger, or about the passage of Idaho's firing squad legislation. Buttons or other apparel with words, photos, or artwork that can be observed by the jurors, since such conduct poses a coercive threat to the jury's ability to remain impartial. In court proceedings in Latah County, a family member of victim Kaylee Gonzalez wore a T-shirt to court related to the passage of Idaho's firing squad legislation. What do you say there, G's? Think you are biased? The T-shirt read "Justice for Kay." And Idaho Bill 186, shots fired. Should be Idaho Bill 187. This must not be allowed in any future courtroom proceedings. Yeah, I would agree. Trials must be free from coercive or intimidating atmosphere. But, third, Mr. Kohberger requests the court's guidance to include his family members' presence in the courtroom. His immediate family consists of his mother, father, and 2 sisters. Mr. Kohberger's Sixth Amendment right to a public trial would be violated if his family is excluded. Conclusion. The scope of the court's guidance as requested by the state's motion in limine, immediate family members, should be broadened to include those members stipulated to State Exhibits S1, outlining court decorum of the spectators in the courtroom during the entirety of the court proceedings, including the trial, to prevent an intimidating or coercive atmosphere, and 3, inclusion of Mr. Kohberger's family. Signed, Alyssa G. Massoff. So, let me ask y'all a question. I mean, it seems to me that if Bryan Kohberger's family, which consists of his mother, father, and 2 sisters, are going to be witnesses by the state to testify against Bryan Kohberger, wouldn't it be futile to request that his family be allowed to be in court with him? I mean, wouldn't the state already have them in court as witnesses, and it wouldn't be necessary to ask for them to be allowed to be there? And would they really want his family to be sitting right behind him during an entire trial, letting the jury see his family sit there and then watch his family get up and testify against him? That would be kind of detrimental, wouldn't it? So it doesn't make a lot of sense there. So maybe, I don't know, maybe pay attention to what these docs are saying and don't take every mainstream moron's suggestion about things in this case, and maybe you'll have a better grasp of what's really going on. I don't know. Now, am I blind to the possibility that the state may be forcing one of Kohberger's family members to testify against him in this thing under threat of arrest if they don't? Well, no, I'm not naive to that point, but all I can do is take all of the evidence, the totality, and look at everything in its own right, and then make an educated decision based on the totality of the evidence that's been presented to us. And I think you would agree the totality of the evidence suggests that Bryan Kohberger's family did not turn him in and is not going to testify against him. So who is those witnesses that the state is going to be bringing? Yeah, probably more of those witnesses that, we really shouldn't be trusting to say a whole lot in this case. But, I could be wrong. I've been wrong before. But based on what I've read, I don't believe I am in this case. And I'll let you form your own opinion. Please like and subscribe to this channel. Post your comments, your thoughts, criticisms. I'll have you another one out later. And until then, Pavarotti is out.